today's digital world, your face, your messages, and even your voice can be shared in a second, sometimes without your permission. From wedding photos plastered on billboards to WhatsApp chats going viral, and from secret call recordings to leaked voice notes, the lines between personal privacy, consent, and creative rights are blurrier than ever. In this episode, we explore the legal and ethical challenges of image rights, private conversations, and recorded calls under Nigerian law. What's legal, what's not, and how everyday Nigerians can protect themselves in a world where everything can be screenshotted, shared, or recorded in an instant. I am Cecilia Meme, and welcome to Justice, a lawyer's hangout where we dissect legal issues with intent to educate the public. And today we'll be discussing screenshots, photos, and secret recordings, navigating privacy and consent in Nigeria. Joining me to discuss this is Chidi Odo. Welcome, Counsel. Thanks for joining us on today's episode.
Thank you for having me, Cecilia.
Yeah, so let's quickly dive into the conversation. Under Nigerian law, who really owns a photo? Is it the person in it, the photographer, or the person who posted it online?
Well, under the Copyright Act, the proprietary interest in produced photograph belongs to the person that took the photograph.
Okay.
That's the basic foundation of the law. However, what he has is only the intellectual property in the product of the picture.
Okay.
And the owner in the picture also has image rights to the picture. So it's like a convoluted issue.
Okay. Okay, so under the Nigerian law, the photographer has intellectual property rights, while the person in the photo has an image right.
Yes, image right.
Okay, let's quickly take a look at this video before we move into the next one.
Good evening, everyone. Good evening, good afternoon, depending on anywhere you are watching this video from. Please, I want to beg Mr. Monday and Doris, his wife. In any way I've wronged you, I'm really very sorry. Like, I've messed up. I fucked up in a big time. I'm really very sorry. Please forgive me. Please. Megba, Ami, Atami, Ami, Amantimi, Amokumi. Metedojo, Ushemaki, Unfokop, Olakunya, Kana, Dupekuna, Kabekuna, Shaolin, Todojo. Ishene Bene Uche, no Megio, Joe, Ishene Bene Uche. Ibebo, Ochaka, I think Memumi, Ushene Bene Uche. But Olakideba, Olakide, Adejo Limoto, Metodojo, Boduk Megi video, Equan.
Okay, so from this video, you could see a lady crying and pleading. What transpired that led to this video being trending online was that this lady was caught in a particular environment. She was videoing a man that was in the same space, probably with the intention to send it to the man's partner, and she was caught. So imagine you going out to a public place, maybe an event, it could be a club, it could be an hotel or something, and then your partner sends you a video of yourself in that place. Looking at this video, Section 37 of the Constitution guarantees privacy. But in the age of screenshots, what does privacy actually mean today in Nigeria? Can sharing someone's private conversation or private moments actually land you in legal trouble? Does it amount to a breach of privacy?
Well, the answer is in the affirmative.
Okay.
First of all, there are hierarchies of norm. Section 12 of Universal Declaration of Human Rights protects privacy.
Okay.
And anything that will bring honor or lower the dignity of a person is prohibited under Universal Declaration of Human Rights.
Okay.
Also, in our national law, Section 37 stipulated that the privacy of citizens are guaranteed. Not only guaranteed, they are guaranteed and protected.
Okay.
Therefore, if you are doing anything that breaches privacy of home communication, privacy of telegraphic communication, anything privacy, if you breaches communication, if something that is meant to be private and you post it on social media and then communicate it to general public, that's the clear breach of right of privacy under the law.
Okay. So let's bring this conversation closer home. Imagine a wedding photographer uses a bride's photo on a billboard or maybe for some other commercial purposes to advertise their studio or anything else. He never sought for consent. The lady's photo is all over town, or the couple's photo are all over town. Their friends are tagging them, their family overreacting, and the individual is embarrassed. Under the law, does she have any legal rights to stop that photographer?
Well, let me give a legal background. We have already stated as a way of foundation that the intellectual property right to a product of a photography is owned by the photographer. However, the image right is owned by the person who is on the picture. However, there are creative ways to navigate this legal conundrum. First of all, there's what we call image releases. For instance, if a photographer takes a model or celebrity picture, you can sign a contract. I have now authorized you, what is called in law image releases, to release this picture and produce it as you like. Sometimes also, if a model commissions a photographer to take a picture, the photographer can give the person trade for print, giving you authorization to print this and use as you like. Now, coming to the photography, wedding photography we are talking about, the photographer has the intellectual property on the photo to do whatever he likes with it. However, he cannot use it for commercial purposes. He cannot exploit the value in the picture for the purpose of promoting his business without the consent of the person, inside, because that is a breach of right of privacy under the law. Because everybody has right to protect their own image and likeness the way they like. Remember, by Section 25 of the Data Protection Act, you have right to use the image, likeness, data, or anything pertaining to anybody in legal form. Using such to promote your businesses or advertisement or for any commercial purposes or commercial exploitation is not allowed by the law. The law is that you have rights in the picture, but you cannot use it to broadcast somebody's private. You don't know whether the person wants the picture to be in the billboard or not. For you to do so, you must seek the consent of the owner of the picture to protect the person's image rights.
Okay, this brings me back. There's this scenario that occurred a time where a friend, she contacted me, I remember very clearly, where after their wedding, they were no longer in Nigeria, sadly. And then I got a call. She made mention of the fact that somebody called her, that they saw a picture. In fact, that was a wedding picture. They saw it in one of these popular real estate company, their billboards down south, around Ugeli or thereabouts. So she was like, she began to wonder when she got the call. She was like, no, she didn't consent to a picture being used as an advert. She doesn't have any affiliation with the company, the real estate company in particular. And she and the husband, they reached out to me. They needed to know what they could do at that point in time. And then I began to wonder, how can somebody enter? Because we couldn't even tell if at that point, if it was the photographer that gave her the picture, or could it also be that if people go online and they search for pictures, they can just take up any person's picture just for the purpose of business, irrespective of the fact that whether the person wants their privacy or not, no consent, and then they use it for business. So coming from what you just mentioned, it is actually not proper. So they must sought for consent before they can carry out such act.
Yeah, well, the issue is that privacy is the right to be left alone. I don't want my person, my image or my likeness or my communication or my chat, either with my wife or my spouse or my medical record or my financial details, BVN, data, account number, or my condition or my belief or anything to be in the public domain. Therefore, if you put my picture, my image or my likeness in public domain, you are infringing on my privacy. That is the position of the law. The courts have held in Wala and the Boy State Independent Electoral Commission that we even have right to protect who we vote for. You cannot force me to come to the public and stand behind anybody. That is the breach of my right of privacy, that I want to vote for somebody in privacy. So if you take somebody's wedding picture and commercialize it, there's a boundary between having the intellectual property in the property and also commercializing it and exploiting it for commercial gains. Once you do that, you are running foul of the law.
So how do laws like the Copyright Act or the Data Protection Act balance creative rights with personal privacy in an instance such as this?
Well, under the Copyright Act, the question is the product itself. Is it matter that can be medium? It depends on the medium where the product is produced. For instance, if you take a photograph of somebody You know, why we are talking about photograph of a human being is because a human being is involved. Because if a photographer takes maybe a natural scene, a mountain, an ocean, trees, forest, nobody will have any problem with that.
No, we've actually seen instances where photographers lay claim to natural scene.
No, that's why I'm saying that when he does that, he's the one that has the intellectual property to those photographs. But because a human being is involved, he has rights to the product itself, but he does not have the right to commercialize it, to distribute it, to use it for advert or any commercial gain. He must seek the consent of the person who has the image right. Image right is a multi-billion naira business. For instance, if you use Ronaldo's picture to do advertisement, it's generating millions because associating with him brings view and everything to them. In modern commerce, using somebody's image like Victor Osimhen, who is one of the best strikers in the whole world, to do your advertisement, is a very big commercial issue. So before you use their image and likeness, you must seek their permission. Even if you are the owner of the photograph, you don't have any right to commercialize their image without their consent. That is why it's always better if you are engaging a photographer for a wedding, sign contract with him that you are transferring all the image I use in this photography for me. To me, I'm owning the whole intellectual property. I signed the intellectual property.
But do they agree to signing?
Yes, that's what they
request. Don't they request for a fee?
No, they request for a fee, but to avoid this dispute, intellectual property is a right that can be assigned, that can be mortgaged and do everything. It's okay. I'm giving you this. I know that you have the intellectual property, but I want you to assign it to me for a fee. Once that is done, final, you will now revert to you. That's the best way to protect it, especially for wedding and serious occasions, to avoid all these lingering disputes about image rights and private.
Yeah, as well as even for birthday occasions, delivery. Sometimes you see maybe a husband and wife, they give birth to their child, they went for photo shoot, and the next thing you are seeing their pictures on social media. The best thing is to seek for consent. So now let's flip the script a bit. The photographer might argue that, oh yes, I took the picture, it's my creative work, I own the copyright. That's correct. We agree under the Copyright Act. So where do we draw the line between a photographer's ownership right and a person's right to control how their image is used, especially when it is for commercial gain? Does consent override copyright? Or does the creator's right come first under Nigerian law?
See, the question is, you have the intellectual property. You took the picture. You have the intellectual property in this picture. Fine. Nobody is disputing that. But for you to disseminate it to the public, to use it for commercial purposes, to use it for advertisement and marketing, you have crossed the boundary of the ownership. You must seek the consent of the person whose image is on the picture. In fact, there are a lot of disputes about all these things. There was a time, I think Kate or somebody did advertisement for people. When the time they agreed elapsed, they continue using the product. Called the lawyer to write to them that the right to use her image has expired.
As ended, wow.
Yes, and they had to put it down or come for another engagement. The mere fact that you took the picture does not mean that you have unlimited right. It's just a continuous right to use it, to exploit it and commercialize it. So that's why, to avoid this argument, it's always good to have agreement on this. I'm going to engage your services to do my wedding or cover me. I'm paying you this. Transfer the intellectual property to me. That is, in fact, that is creative ways lawyers, use to solve all this problem. In the receipt or any document you are signing with the person, fine, I'm paying you. The intellectual property is transferred to me. That's okay. But you don't have right to commercialize somebody's image. It's breach of privacy and image right.
All right, let's take a break. We'll be back. Don't go anywhere. Stay tuned.
Camera rolling. Light set. Sound check. And action.
Hello everyone, welcome to today's program, a program where we get to talk about the daily affairs around technical issues with intent to educate.
This is the perfect space to create professional quality videos, recording news, podcasts, and all media content. With top-of-the-line cameras, studio lighting, soundproof spaces, we provide everything you need for a seamless shoot. Our fully equipped studio ensures high-quality production every time. Enjoy a comfortable, air-conditioned environment with professional-grade gear and expert support. Contact us now or visit our Abuja location to reserve your spot.
Welcome back. And if you are just joining us, this is Justice, a lawyer's hangout where we dissect legal issues. And today we are discussing screenshots photos and secret recordings, navigating privacy and consent in Nigeria. So let's dive into the conversation. Beyond pictures, people record phone calls all the time in Nigeria, sometimes for evidence, sometimes just in case. But what does the law really say about recording someone's call without telling them? Is it legal, or could it count as a privacy violation under Section 37 of the Constitution or the Data Protection Act?
Well, recording somebody without their consent, you are running foul of the law. You are running foul of Section 37 of the Constitution. You are running foul of Section 12, Article 12 of Universal Declaration of Human Rights. You are also running foul of Section 25 of Data Protection Act. Before you record somebody, you must get the person's consent. However, it depends on why you are recording the person. If people are in public domain, like a government office or official ceremony, such record is allowed. However, you know this what they call a prank video, or where you video people where they are in their natural state or in clownish position, and then you post it online. That is in addition to being a criminal offense of cyberbullying and cyber stalking. It is also actionable in law for breach of privacy, because you must seek consent of somebody to record them, and then depending on what your intention and what you want to use it to do, and also if it is intended that this is supposed to be private. For instance, let me give you an example. If a lady is going on the road and maybe you had malfunctioned wardrobe, and you snap her picture and see her nakedness and then post it online, that is a criminal offense, and that is breach of her privacy. So the mere fact that you have right to record, you can record for public purposes, for general purposes, maybe public institutions, for public occasions, and etc. But when it is meant to be a private thing and you record and post it, you have run foul of the law.
Okay, but are there exceptions?
There are no exceptions. You can record in. I said you can record in public.
Okay, for cause, don't you think where both parties agree, it can be an exception?
When
For
then you have
example,
already,
I'm calling you and I'm telling you, oh, I'm recording this call.
yeah.
Does it not become an exception to the general?
No, that's what I say. That it depends. It depends on even the purpose.
Okay,
If you send me a message now that you have 1 billion naira in your account, this is a private conversation, and I go and post it on social media, it's a very dangerous thing. Armed robbers can come, kidnappers can come and do it. That is the breach of privacy. This is a private conversation. The question is it meant to be private? Once it's meant to be private, it's not supposed to be seen in public domain. That is the line.
Okay,
the court will now put it on a weighing balance and know, is this supposed to be private? Or if you go to the hospital and I tell you that somebody has this illness that is, that cannot be treated, you go and post it on social media and everywhere. That particular information is meant to be private. It cannot go. So the
court can also order for a conversation to be made public.
Of course, court can give order, especially for law enforcement agents, or to prove us for it to be made public. But there are some private and sensitive informations which you on your own you are not supposed to post to the public, because it infringes on somebody's right of privacy, which is protected and guaranteed under Section 37 of the Constitution of the Federal Republic of Nigeria.
Okay, I don't know. There are some government institutions that not even just government, even private institutions. Sometimes when you call on phone, let's say you are calling MTN, there's this thing they used to say, your call is recorded for, there's this recording line that they always say that they are trying to notify you that the call is being recorded for, I don't know, I think in line with National Communications Commission. So I think that's also a must.
Yeah, that is like a warning for you that this your call is being recorded. If you don't consent to it, you stop the call. But if you consent to it, continuing the call shows that you have consented to the call, and the call will be recorded.
For those that might be wondering or that might be worried about their conversations, private conversations with network providers, they should be aware that they've granted implied consent.
The network providers are data processors and data controllers, so they are not supposed to publish those information without legal justification. The mere fact that they have private data, your voice or recording or anything, does not mean that they should publish it without lawful justification or reasons.
But from what you've mentioned, if you move past that stage where they notify you or give you a warning, you've given implied consent.
Yes, you have given implied.
So now, what counts as consent in Nigeria?
Well, there are two types of consent. Express consent. I want to use your picture to promote my music. Consent. Do you accept? Yes. I want to record you to promote my business. You say yes. That is consent.
Does it have to be in writing?
It must not be in writing. It can be oral. But you know that they say that the faintest of the ink is better than memory. So it's better that you write it so that people will not argue. Like two angels living in a city. One is arguing like this, one is arguing like. So they need to write it down so that they will know the law to follow.
So in the absence of writing it down, are there other forms of consent? Or are there other forms or ways in which consent can be given?
Of course, consent can be given. For instance, you have mentioned that you have MTN will warn you that this your call is being recorded. You have impliedly given consent. I want to make a call with you now and say, please, I'm notifying you on speaker. You're on speaker. So your consent is being sought that you are going to be, your conversation will be in public. That is implied consent. Once you continue the conversation, then there's implied consent.
So how do courts treat digital evidence? Screenshots, recorded calls, recorded videos. Can you use them in court?
Of course. Now,
how do lawyers prove the authenticity of it?
Well, that is a different thing. That is for forensic experts. I'm not a forensic expert. But the law says under Section 84 of the Evidence Act that for you to tender digital evidence or computer-generated evidence, you must attach certificate of authentication. Okay. Once you attach certificate of authentication showing that the computer was working when you did it in course of business, and you confirm the authenticity of what you are printing, the law will presume that it is correct. The law will presume that it's, presumptions are not conclusive.
Yeah.
If the other party is now saying that that is not correct, then they can summon the digital provider like WhatsApp, Facebook to produce the copy, certified true copy of the conversation. In fact, there's a matter I did. There was a call recording. I called the MTN to produce CTC of the recording, and they came with a flash drive of the CTC of the recording, and it was intended the court to show the authentication. So if you are saying that this is not what you said, or you are disputing it, then the provider of the network will now bring certified true copy of the recording, and then tender before the court, which is admissible.
It becomes admissible.
Yes, it becomes admissible.
Once the authentication is certified.
Once authentication is satisfied.
Okay, so what practical steps can everyday Nigerians take to protect their images, their chats, their calls, or their recordings online before someone else shares them without their permission?
Well, it's very simple. You have to, when an information or is in public domain, you have presented it in public. If you are a public figure or a celebrity or the president of Nigeria, and I can take your picture because you're already in public domain. However, we must engage in factors of authentication, 3-factor authentication, encryption, and other types of cybersecurity measures to make sure that your pictures you don't want to go outside will not be. And you have to also be careful. You have to, engage in behavioral attitude that will prevent our document.
Yeah, so
have to know what we are doing.
Even the ones that are posted public, even if I post my pictures, I can also, maybe I might want to prevent redistribution.
Yes.
I think taking a further step to even watermark them can also
watermark can also
guide.
Encryption can also guide, or even warning that this is the copyright of Mr. X. Please don't redistribute.
Yes, that's true.
Warning, putting a copyright warning on this thing.
So product, I can put on my Facebook post that this picture should not be shared by any other person.
Without your consent, yes, because it's intellectual property. It's allowed.
Okay, how about, I think what we also need to let them know is that people should read photo contracts very well. Because you might sign something at the end of the day, you don't know what you're signing. You don't know if you signed your rights to them.
That's what they call small print. They always come in small print.
Yes.
If you're opening bank account, they give you small print. If you want to open Instagram page, they'll give you small print. They will just click yes, agree. The issue that most people don't read it. But when there are issues, you will see that tiny print is also implied consent. Do you consent for who to use your go-to? Say yes. Do you consent for Facebook to say yes? So you have given consent. You cannot cry foul after that.
But you can also report unauthorized data use.
Of course.
Okay, so now for someone that there's a certainty that my privacy rights have been violated, what can I do? What should I do? What remedies are available?
It depends on the type of violation. If it is in form of cyber crime, you report to the appropriate portals in the police. If it is in form of a breach of privacy, you file appropriate applications in the Federal High Court under the Fundamental Rights Enforcement Procedures to enforce your right to this thing, to privacy, as guaranteed by Section 37 of Constitution of Federal Republic of Nigeria.
How about, I think some of these things, they also come under cyberbullying.
That's why I say cyber crime. You can cyberbullying, cyber stalking.
Section what?
And even Section 24. And even defamation. There's a way you can present my picture and my image in the general public. It can injure and discredit my character, which is defamation. Remember, there are civil and criminal defamation. You can go for any of them you like, depending on how. Defamation does not even need to be word. It can be action, caricature, or cartoon. Okay. You can bring action.
Okay, so finally, before we go, What's the ethical line between creative expression and invasion of privacy? When does sharing content become illegal or wrong?
Well, there's what they call fair dealing.
Okay.
Fair use and fair dealing.
use.
Fair use, fair dealing is allowed. For instance, if you are using somebody's creative work or artistic work for purposes of research, education, news, literary purposes, those ones are allowed, provided you are not commercializing it. But however, it is also better to seek the consent of the person. But under the law, the general exception, they can use it for educative purposes, maybe for religious purposes, for teaching, for criticism, academic work. Those ones are allowed under the law.
Okay, do you have any exit recommendations for our viewers so that they can understand their rights?
The problem is that most people don't like to enforce their rights. But I'm telling you, if you feel that your privacy has been violated, report to the law enforcement agency, report to the Nigerian Data Protection Agency. They have adequate mechanism to protect your rights. And sometimes even test the law by hiring a lawyer to go to court to challenge such an invasion of privacy.
So sometimes you've heard from Chidi, he said sometimes you need to test the law. Because the truth is, if you do not test the law, you would not know that that right exists. Thanks, Cancer, for joining us today. Thank you for joining us. So our viewers, whether it's a photo, a chat, or a voice recording, your personal information can spread faster than you think. Nigerian law is catching up, but the safest bet is clear consent and respect for privacy. Thanks for joining us, and remember the golden rule: if you will be upset seeing it shared, don't share it. Also remember the conversation continues on all our social media platforms at LJE Nigeria. We will see you in the next episode.